Privacy, something so basic, yet it wasn't always considered a right in India. Let's understand how Article 21 made privacy a part of our constitutional freedom. But before we start the video, let's take a quick look at what Record of Law is all about, your go-to platform for legal insights, articles, and research opportunities. Record of Law is a premier online platform dedicated to providing comprehensive legal insights and knowledge, designed as a valuable resource for both law students and legal professionals. It offers an extensive collection of legal articles and case summaries covering a wide range of topics from fundamental principles of law to the latest trends and developments. Founded with the mission to educate and empower individuals in the legal field, Record of Law aims to make high-quality legal information accessible to everyone. The platform believes that informed individuals can make better decisions, contribute meaningfully to the legal community, and drive positive change. Along with insightful articles, Record of Law offers legal research internships that provide hands-on experience and mentorships, helping learners develop practical skills. It also invites guest authors and legal experts to contribute, enriching the community with diverse perspectives. Privacy, something that affects every single one of us. From unlocking your phone to sharing photos online, it's all about your right to choose what to share and what to keep private. But did you know that for a long time, India didn't even recognize the right to privacy as a fundamental right? In this video, we will explore how that changed and why Article 21 of our Constitution is at the heart of this transformation. The right to privacy is not just about secrets, it's about control. It means you have the power to decide who knows what about you. It's about dignity, safety, and the ability to make your own life choices without interference. This simple question, does the Indian Constitution protect privacy, has been debated for decades. The answer wasn't always yes. Let's see how that changed. Article 21 says no person shall be deprived of his life or personal liberty except according to procedure established by the law. At first glance, it seems to protect only physical life, but over time, courts expanded it to include everything that makes life meaningful, including privacy. The Supreme Court interpreted Article 21 in a broader sense, not just the right to exist, but the right to live with dignity. That means it includes the right to education, health, environment, and later the right to privacy. In simple words, privacy means the right to be left alone, the right to make personal decisions about your body, your data, and your life without unnecessary interference. Think about it. You lock your room, use passwords, or choose who to share things with. These are everyday examples of privacy in action. It's not abstract, it's deeply personal. In 1954, the Supreme Court decided the MP Sharma case, which involved government searches and seizures. The court said the Constitution didn't mention privacy, so it's not a fundamental right. That set an early precedent: no privacy protection under Article 21. In 1962, in the Kharak Singh case, a man was being watched by the police. He argued this violated his privacy. The court disagreed, saying privacy isn't guaranteed by the Constitution. However, one judge, Justice Subba Rao, disagreed. He said privacy is a part of personal liberty. His opinion would later become the foundation of future rulings. With the rise of technology, phones, computers, internet, privacy issues become more complex. Our personal data was being collected, stored, and sometimes misused, making people realize privacy needs legal protection. When the Aadhaar project started, people were asked to share fingerprints, iris scans, and other details. Many questioned, what if this data is misused? Can the government store everything about us? This debate reignited the fight for privacy. Different court cases gave different opinions on privacy. It became necessary for the Supreme Court to make a clear, unified decision once and for all. Justice K.S. Puttaswamy, a retired judge, filed a petition arguing that Aadhaar violates the right to privacy. This case would change Indian constitutional law forever. To resolve the confusion, a special 9-judge bench was formed, one of the largest in Indian history, to decide whether privacy is a fundamental right. In August 2017, the Supreme Court unanimously declared the right to privacy is protected under Article 21. It is intrinsic to life, liberty, and dignity. This was a massive step for individual freedom in India. The court overruled the earlier cases that denied privacy. What was once ignored now became one of the strongest fundamental rights. The judges made it clear privacy isn't just for the rich or powerful. It is essential for every individual's dignity, freedom, and personal development. The court said privacy covers three main areas: physical privacy, informational privacy, and decisional privacy. Together, they protect our bodies, our data, and our choices. Physical privacy means freedom from physical interference. No one can enter your house or search your body without legal authority. It's about feeling safe in your own space. In the age of the internet, informational privacy is key. It means having the right to decide how your personal information like photos, contacts, or location is collected, used, and shared. Decisional privacy protects your personal choices: who to marry, what to eat, what to believe in, and how to live. These decisions are your alone. Today, technology collects a massive amount of data, your habits, preferences, and even emotions. That's why privacy protection is more important than ever. The Supreme Court clarified that the right to privacy is not absolute. It can be restricted, but only under strict legal conditions. To justify limiting privacy, the government must show three things. 1. There is a valid law. 2. There is a legitimate purpose like security. And 3. The restriction is proportional, not excessive. The state may collect data for national security or crime prevention, but it must follow the law and cannot use these powers arbitrarily. Every post, like, or share reveals something about you. Many apps collect your data even when you don't realize it. Always think before you share. In 2023, India passed the Digital Personal Data Protection Act. Its first law focused on protecting citizens' data from misuse by companies and the government. This right allows you to request the removal of your personal information from websites, especially old or irrelevant data that can harm your reputation. In India, there have been instances where phone tapping was done without proper legal permission, even involving politicians and journalists. The court's letter said such actions violate the right to privacy unless done under clear, lawful procedures. In 2021, reports claimed that a software called Pegasus was used to hack the phone of activists, journalists, and public figures. This raised huge questions. If the state itself can spy on citizens, what remains of privacy? CCTV cameras help reduce crime, but they also raise privacy concern. If every movement is recorded and stored without consent, it becomes surveillance, not safety. When we post our personal details, we may unknowingly allow companies or strangers to use them for ads, scams, or even identity theft. The internet never forgets. Being in a public place doesn't mean giving up your privacy. Recording someone without consent or sharing their photo online can still violate their right to privacy. Freedom of speech allows us to express ourselves. Privacy allows us to choose when not to speak. Both are essential for personal autonomy. When private data like caste, religion, or health is leaked, it can lead to discrimination. Protecting privacy therefore also protects equality. Every person has the right to practice or not practice religion without interference. Your faith or lack of it is part of your personal identity protected by privacy. In conclusion, the right to privacy under Article 21 is not just a legal protection but a cornerstone of individual freedom and dignity in a democratic society. It empowers every person to make independent choices, control personal information, and live without unwarranted interference. As technology advances and data becomes the new currency, safeguarding privacy has become more crucial than ever. While the state may limit it in matters of national interest, such restrictions must always be fair, reasonable, and proportionate. Ultimately, the right to privacy reminds us that the true liberty lies in the ability to live as we choose, securely, autonomously, and with respect of our personal space and identity.